Everybody say, ah. Say, oh, oh. Say, how can I express my gratitude for all the many things you've done for me? Words are not enough, to say thank you. Say, Lord, you are my everything. You're my everything. How can I express my gratitude? How can I express my gratitude for all the many things, you've Father, you done for me, yeah. Words are not enough to say thank you. So Lord, you are, you're my everything. Say, I call you Zion. Lord, my provider. I call you Nisi. You are my battle. I call you Rapha. Hey. You are my healer. Say, Lord, you are. You're my everything. I call you Jireh. Lord, my provider. I call you Nisi. You are my banner. I call you Rapha. You are my healer. Say, Lord, you are. You're my everything. Uya matinyana. Uya matinyana. Uya matinyana. Oh, uya matinyana. Hello, lovely people, wonderful guys around there. And I know that you are there and you're feeling so relaxed because we're bringing you the community and the law. My name is Owusu Frimpong and I am privileged to be the host of the event today. Changes to immigration rules. Should I renew my pre-settled status or wait for the automatic renewal? That's the question we're going to address, and Lawyer Charles Asmah, our guest, will be doing justice to that. So, 1, 2, 3, let's get into this together. We are live on BWTV, BW Solicitors Facebook page and YouTube, and of course all the social media platforms are ready and live and kicking. It's a community and the law. Today, the very first Saturday of August 2023. Are you ready for that wonderful experience where we're all going to be together to listen to something so tangibly good, something that will help you stick to the right side of the law and know about any changes that have come when we talk about immigration rules and stay here in the UK. Then again, also to give you the opportunity to ask any question to the lawyers for them to answer for you. Remember, when the lines are active, 0399208468, or you can send a WhatsApp message or voice note to 07950422780. Once again, my name is Owusu Frimpong, and I am privileged to have, as usual, somebody from BWF Solicitors, our sponsors, to really help us do that. And I have no other person than my friend, my brother, and, well, when it comes to this program, my colleague, I would say, Lawyer Charles Asmah. Because, good afternoon. Your line is muted. If you could check that one for me.
Good afternoon, Brakoku. Can you hear
lovely.
me?
Good afternoon. How are you doing, boss?
Pleasure. I'm doing well. Pleasure coming your way once more.
We thank God for mercies, yes. And to our viewers, we're also very excited that BWF Solicitors, you never leave us alone. Every Saturday afternoon, we have the opportunity to meet you. And tonight, or this evening, this afternoon, so to speak, we're going to share knowledge and also know what has happened. I believe you're excited and ready for that.
Definitely.
Right.
Well, folks, BWF Solicitors, our proud sponsors, and our resource person is coming from their fold. And we're going to look at that question that I posed at the beginning. Changes to immigration rules. Should I renew my pre-settled status? I should just wait and say, okay, well, forget about it. When it's the time for automatic renewal, I'll have to do that. But if you're so confused as to what to do, you have to stick and stay. If you have any question to ask, please don't hesitate to put that in the comment section on Facebook, BWTV, BWF Solicitors, and on YouTube, BWTV, BWF Solicitors as well. I've got Asante Richard online already, Gifty Achan team online already, and the rest of you, we are waiting. And we want to say thank you to BWF Solicitors. And when we're back, we start the conversation. It's live, and the program is The Community and the Law.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Welcome to City of Favor Estates, developed by Sarenano and Sons Company Limited, located in Tema Community 25 extension off the Tema Aplau Road. City of Favor Estate offers 2, 3, and 4 ensuite bedrooms on 118, 138, and 178 to 190 square meter lands, respectively, to give you the needed space. Our gated estate homes are designed with you in mind and have all the necessary amenities located in a serene environment with security. You too can be a homeowner at a price that suits your budget with flexible payment terms. Choose City of Favor Estate for peace, comfort, and safety. Reach us on 0542 563 250 or 0243 235 518.
Okay, we are back. Thank you very much for sticking and staying. And Ajimine, hey, class prefect, long time no see. But on that to say, I know you are doing so very well. Free legal education, you say, Abdul Salam bin Abdullah. Hello, Ghanaians in Germany. Ghanaians in Germany don't get this chance. Yes, you have the chance. It's EU law and all the other bits. You definitely would benefit from the program. So pick up the link, share with others, and let's get moving along. This afternoon, I have this very interesting piece of information I would want to share with you. The Home Office cannot refuse an application or your visa at the airport on grounds of dishonesty or some other serious allegations without first informing the person of their concerns and giving them a chance to respond. The courts have said that it is unfair to do that. This is known as a minded to process. Now, I will want to, first of all, get lawyer Charles Asmah to take us through that. When I get to the airport and I'm entering the UK, they can't refuse my application or visa at the airport on grounds of dishonesty or some serious other allegations without first informing me of their concerns and giving me a chance to respond. Can they really not do that? Lawyer Asma.
Thank you very much, viewers and listeners. So, Ragoku, the nugget set out what and what cannot be done. And here we are looking at intention to refuse. And especially where you are alleging that the person has been dishonest in terms of the application information provided, the documentation provided, and possibly at the point of entry, the information that they have shared suggests that they have not been truthful. Now, these are allegations and ought to be proven. And because of that, you cannot have a blanket approach to conclude. And therefore, you have to give the person opportunity to answer what you are suggesting to them. And that is called a minded to refuse notice. So you have to warn them that for X and Y reasons, we intend to refuse your application, or even though you are already in, cancel and refuse it. And if there is any explanation, you have to provide. And this means if you have any evidence, you can also offer. So you have put the person on notice that there is intention to do that. And because it's allegation is allegation, you have to give opportunity to the person to explain. And therefore, the courts are very, very clear on that, that where there's issue or there's aspect of intention to refuse, and that borders on dishonesty on the part of the applicant or the holder of the visa. It doesn't matter whether they have entered the UK or they are in the UK and they are making application, or they are making application from their host country or home country. It doesn't really matter. If there is question of dishonesty, maybe it false representation or anything like that, that's serious. So what the courts have said that you have to give them opportunity to explain or to represent, to give a representation on that front to make it clearer before you conclude on what you are thinking. In other words, the caseworker or the border officer at the port of entry is thinking, and that is called minded to refuse. So from the nugget, we see that there are two case law or two court judgments that came to support the fact that the border officer or the entry clearance officer or the secretary of state or caseworker cannot conclude on allegation and refuse an application unless they have given the person opportunity to explain themselves. And if they are still not satisfied, then they can refuse. In this case, they have to give the person chance, and that is called minded to refuse. And that process of giving the person chance and hearing them and concluding based on the information they finally give you is the minded to process. If you don't do that, the court says that then the process of concluding and refusing is not fair. So it becomes a procedural impropriety. So in the case of Tazim, the case of Bella Jigari, all conclude and point to the fact that the Home Office has a job to do. The entry clearance officer has a job to do. And indeed, the border officer at the port of entry also has job to do. You can see that Tazim, the case of Tazim, Secretary of State, was handed down 2023 in terms of the judgment. And therefore, it's a very, very fresh and current ruling. And the
Now,
case of
let me ask along here that the minded to process, does it mean that the person that is being accused here has a right to legal representation, a right to a lawyer? So if they accuse you, can you just say that, let me speak to a lawyer or somebody who can represent me? Or I would have to answer the questions there and then.
So, what this is pointing to is that once the person arrives and they are interviewed or questioned, they cannot conclude on whether to cancel and refuse until they have given them opportunity to make a representation. And that representation can be done themselves or through their legal representative. But the point here is that the Secretary of State has a duty through to do this through its agencies, the border agency or the embassies abroad or the home office in country. There is a duty on their part. So if somebody has entered the UK, arrives and interviewed, and they intend to cancel the visa and refuse, then they have to be given opportunity to explain themselves. And of course, that explain what it means is that they will be given opportunity to go. That's the bail. And sometimes they won't cancel until that process is completed. In the past, they won't, but if ever they do cancel without giving the person this opportunity or following through the process, what the court is saying is that it becomes unfair and the individual can challenge them on their procedural impropriety.
So in that case, can the person just enter and kind of answer the questions, and if it's not satisfactory, then they will ask the person to leave the country? Is that what will happen?
So if the person makes a representation and they are, of course, not satisfactory, then they will cancel and refuse. Cancel means the visa is already granted, so they will cancel it and reissue a refusal notice. Because the first one was notice of grant, and this time, once they cancel, they have to issue a notice of refusal. Now, if you are refused, then of course you'll be given notice that because you've been refused, these are your rights: right of appeal or administrative review. You go through the process, and once the process is concluded, of course you have time to do that. If you are in country 14 days, you have to start the process. If you're out of country, you have 28 days to start the process. But either way, what we are saying is that you have a chance to speak and to challenge even the refusal if they have given you the mandate to refuse notice and they have represented some for giving them explanation and they are not satisfied. You can still challenge that even up to judicial review. But until the process is exhausted, you cannot be asked to leave the country. Once you choose not to appeal or exercise your right in terms of admin review or appeal or judicial review, then they will serve notice for you to be removed from the country.
Okay. Well, that's what the nugget is saying, that the Home Office cannot refuse an application or your visa at the airport on grounds of dishonesty or some other serious allegations without first informing the person of their concerns and giving them a chance to respond. The courts have said that it is unfair to do that. This is known as a minded to process. And based on two cases, as lawyer has explained, Tazim versus Secretary of State for the Home Department, 2023 case, then Bala Jigari versus Secretary of State for the Home Department as a 2019 case. And that is what our nuggets have said. And we would want to keep that in mind. Maybe I'll ask you a question on that. So keep that in mind and keep going on. Tili Juma, thank you very much for coming on board. Akuya Nima, you've been called Nana Beye Ajimai, Nana Sapon, Bob Asari, Ezekiel Johnson, Kofinat back in Mayor 1. Lovely family, we all here, and I want you to pick up the link, share, and get others to join us as well. It's free legal education, and we are coming your way courtesy BWF Solicitors. BWF Solicitors are located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, North London, N15 4NP. They work Monday to Friday between 9:30 in the morning and 6 p.m. in the evening. Call them on 0208 493 7340 or 077 127 61884. BWF Solicitors are trusted legal partners. So trust them, go to them, speak to them. We give you the opportunity to have legal education and free legal service on our media platforms Thursday morning, Friday morning, and Saturday afternoon, as we are doing now. And this is BWTV, and the program is The Community and the Law. Okay, thank you very much for joining us. And we're going straight into our discussion. And today, our focus will be on renewing your immigration status. Now, the changes in the rules have come. Should you renew your pre-settled status before the automatic renewal period? I may dare to say yes, no, maybe so. But in the meantime, I know that when you're so confused and you don't know the direct answers, you ask. And we're going over to BWF solicitors to ask. And as I mentioned earlier on, my guest today and my resource person, so to speak, is lawyer Charles Asmah, is a lawyer at BWF solicitors. Once again, let me welcome lawyer Charles Asmah. Uncle Charles, good afternoon once again.
Good afternoon, Brakoku.
Thank you
How are
very
you, sir?
much for joining us. Now, it says changes to immigration rules. So it means that the changes have come, haven't they?
Yes.
What are they?
Right. So we have a range of changes across board, the spectrum of the immigration gateways. So we have change to do with family migration, Appendix FM. We have changes to do with EU migration, Appendix EU. We have changes to do with skilled worker migration, Appendix skilled worker. We have changes to do with um, ADR, which is adult dependent relatives coming to the UK for care and support. And in fact, a range. And therefore, we say that almost every area of immigration gateway is touched.
Okay, so then let me dare ask and say immigration rules, the EU, and all the other bits. This change that we are looking at, the question we are asking whether we should renew our pre-settled status kind of relates to those who were under EU rules. Am I correct?
You are correct.
Okay. So when somebody has a pre-settled status, does a person have to renew?
Thank you very much. Before we delve into, because it's gateway specific, and this conversation going to center around EU migration, Appendix EU applications, or you can see that it's specific. Therefore, let me just give the overview that touches on recent concerns that people have raised. There have been lots of phone calls to groups and individuals. One of them that ECTIS is no longer going to be the case. We say that that is not true. ECTIS has come to confirm that the rumor is false, and therefore we should disregard that. So there's no authenticity in the rumor that, or the um, information dotted around that ECTIS is not going to be applicable, and therefore everybody should do exam if they are coming to work in the UK on the skilled worker program. So ECTIS is still working, and therefore if you are applying to work in the UK and you have to prove your English language proficiency, or to, so to speak, any other form of application, you can have your degree certified by ECTIS, formerly NARIC, so that you don't have to do the exam. So that is still ongoing, and there's no information that it's been stopped or cancelled. So that is assurance for those who are worried. The second is
Maybe just not to take the wind out of your sail quickly, and apologies for that. I would want to plead with people. Sometimes when you hear anything, don't just jump to it and take it hook, line, and sinker. Find out. And that's the reason we're having a program like this. And we're so grateful to BWF solicitors to be telling us that when the changes come, you must be rest assured that you get it here first. You will get the very authentic one here first. So don't jump into anything. Some people are doing so many things on several other media platforms, TikTok, Twitter, Facebook, YouTube, and the rest of it. Please find out. Even if when you hear it from here and we're telling you it's authentic, read, go to the right sources and ask the questions. Now, this thing, when I heard it earlier in the week, I was like, what are people doing? When changes come, we'll get to know from the right sources, and BWF Solicitors is right here to do that for us. And as Lawyer Charles Asmah has mentioned, I'm happy he's taken that and addressed it. There is nothing like that. So please disregard it. If you didn't hear it from here, it's not correct. Ola, am I right?
You are right, absolutely right, Brakuku. It's very, very concerning. Unsuspected members of the public, especially those within the spectrum of immigration, become so worried that, oh my God, what's happening? So we are calming the tide and assuring people that ECTIS is still ECTIS, is working, and therefore, if you want to have your degree, a foreign degree certified, just go through the process and have it done for you. It is never cancelled as being reported. The
Okay.
next thing that we want to clarify and to allay the fears of the public is to do with changes to the um, skilled worker program. And one thing that another rumor is that from 7th of August, there's going to be interviews introduced for all those who are applying to come and work in the UK, whether themselves or their spouses. But we want to say that there is no guideline published on that front. And therefore, if there is this announcement, it is not conclusive. And again, we want to say that generally, the entry clearance officers within their rules have the right to invite somebody, just as we talked about minded to refuse. They have the right to request interview appointment so that you come and clarify certain matters. So even if they choose to introduce that is fine. It's something that has existed long before now. But what we are saying is that as part of the rules that came, there is no point like that. It talks about a requirement for information that the caseworker should request information before making decision where they are not clear about certain matters. And even if they decide to go ahead in terms of verification of document, if they decide to go ahead and then to grant, then in their decision, they have to make it clear that if the person challenges it, they have the right to verify the information as part of reviewing the application or reconsidering the decision. Now, let me point this out, Brakuko, on this show that the Home Office brings out these guidance or policies or working document for its workers. And this stems from the parliament and so on and so forth, could be a secondary legislation. Now, once there is a policy is it's just a guide, and there's case law on that front. Policy is a guide. The policy comes to help us or punish us, and for us, members of the public. And therefore, if the policy is going to punish us, we have to look at it carefully. If the policy is coming to help us, and of course, we embrace it wholeheartedly. So, in what circumstance will we say that the policy is undermining our rights and therefore we have to um, question it? The case of R. Begum versus the Secretary of State, and this is a 2021 case, which says that when it comes to policy, policies are there to guide and therefore they are advisory. They are not binding. So policies do not take the preeminence of statutes or case law. So if the law is there and the policy is there, laws always take preeminence over policy. And therefore, if the policy is undermining, this case law is saying that then it cannot be used to override the existing law. And so it will be unfair for it to be used because it's very punitive. So anybody can challenge that. However, if the policy is helpful, then we can embrace it. And therefore, if the policy is good, then it should be used as part of the law. If the policy is not good, then it cannot be used to replace the law. And that is the case of R. Begum, that's the Secretary of State, and it's a 2021 case. So these are the two things I want to
Lawyer,
point out.
a
Or
quick
is
question. If you said the policy is good, who determines that?
So the policy, remember, comes from a secretary of a particular area of governance. You know, the government, a particular government secretary. So we have secretary for for immigration in the UK. So they may propose certain changes. And as we know, we have the Home Office secretary, our mom, Braverman, and she has other immigration ministers, secondary ministers that support her work. They can make a proposal and Parliament can take into account. Then they will review and draft a policy, and that becomes a working document for caseworkers, be it in country or out of country across the embassies of the UK. So it becomes a working document. And the key word is work, a guide, working document. Now, if it's a working document, it's not law, it's a policy. Policies are as good as internal arrangement and procedures. And therefore, if the policy is there and you don't follow your own policy, then it becomes a procedural impropriety for you. But the policy does not take over the existing law. So if there is a law which says that, for example, upon the skilled worker, set out the validity, set out the eligibility, and set out suitability requirements for making an application for the main applicant, for the dependent spouse, and for the dependent child. And therefore, if this is the position, any new policy that tend to undermine this may not be fair to the public. What we are saying is supported by case law. So if policy is advisory, then it cannot take the place of law, statute. So in the case of our Begum 2021 case, the Secretary of State is saying that when there is a policy introduced for immigration purposes, that policy is advisory. And therefore, if the policy is helpful, for example, if there is a policy to say that, right, when you make an application, it has to be decided within 1 day. That is good for everybody, isn't it? Yeah, in that case, we say the policy is helpful. But if there's a policy to introduce something that is inimical or very problematic for applicants, then we say that this policy, though has been introduced, we have to test it or gauge it against the existing law. And therefore, if that undermines the law or that contravenes with the law, then we say that that policy is at odds. If the policy is at odds with the existing law, then we have to invoke the principles within the case of R. Begum, the Secretary of State 2021, to say that though the policy is introduced, so there's a policy introduced on the 17th of July 2023 across the spectrum of the skilled worker program. And therefore, if the policy is not appropriate or not going to help, we have to check it against the law. Home Office is not the law. The law is separate. And therefore, Home Office policy does not take place of the law. And that is the point we are trying to make. So if the policy is undermining, somebody can challenge it, citing the case of R. Begum, the Secretary of State 2021.
Well, if you just joined us, you are with us live on the community and the law. Our guest, lawyer Charles Asmah, has had the introductory something to our discussion this afternoon. Queen Flourish, you are watching with us. Thank you very much. Doreen Dale, Nana Bob, Bernard Weissman is watching. Shaft, Nana Boachi, Tilly Duma, Nako Agbenodze is also watching. Issa Ayuma, thank you very much for watching. Asante Richard Foster Fox, say good afternoon, BWF solicitors and everybody. We have one here from Yabua Kennedy. Nana Bob is also saying good afternoon to Oreku and lawyer Charles Asmah. Now, lawyer, let's look at our very main question we asked. The changes that have come. You have cleared the misconceptions that are around and the rest of it. Now, should somebody who has a pre-settled status renew the status or wait for an automatic renewal? So it means that there's an automatic renewal period that should happen, and people can even do that before the automatic renewal period. What is the difference, and what should one do?
Thank you very much. So we are going to set the context for this conversation.
Mhm.
So we have the European Union bloc, which used to include United Kingdom. From the 31st of December 2020, 11 p.m. evening, EU formally left the bloc.
Mhm.
What it means is that anything prior to that, we have to look at what the agreement is. And anything after that, we look at what the agreement is in
Okay.
terms of deciding anything after that exit point. So the relevant period is 31st of December 2020.
Mhm.
Now, let's go back and look at the source of this whole agreement.
Okay.
So there is what we call Treaty on the Functioning of the European Union. And the treaty was actually put together in 2000, and it was adopted by Strasbourg, the European Commission, in 2007. Now, that charter looks at principles, looks at rights, looks at freedoms, fundamental rights, freedoms, and principles governing the union activities.
Mhm.
One of them is Article 6 looks at those principles and freedoms, and Article 21 of that Treaty on the Function of the European Union looks at rights of members, nationals within those member states.
Okay.
And therefore, we say that EU nationals have rights, and we always say treaty rights, and that is the context. So treaty rights. So Article 21 of the Treaty on the Function of the European Union set out the treaty rights. One of them is that nationals of member states have the right to move to and fro without any restriction. The word is restriction, unconditional movement. So people come into the UK to work, to live, to have a family, and to have their lives, so to speak. But they must do one thing to exercise treaty right, to be working, to support. And that is the key thing. So when you come and say, are you exercising treaty right? If you are, that is it. Now, if anybody came to exercise treaty right, there was no condition that when you come, do this. So you remember all those who came prior to the Brexit conversation, they only arrive and they are given a residence card, blue card, and they live their lives.
Mhm.
You don't have to make any any this and that. Straightforward. Now there's going to be Brexit. So we come together, or the union come together and discusses how they will treat UK.
Mhm.
And there is this agreement. So the Withdrawal Agreement Act comes into being. And part of that is that if you look at Article 13 of that law, the relevant sections of that will tell you that any agreement between us for our members or nationals should have a reflection of the treaty right. So whatever we do, our focus should be to enhance the treaty right, not to undermine it, because it's an existing obligation. So the withdrawal agreement now says that nationals, nationals of those member states living in the UK can choose to live in the UK, but
Mhm.
they have to do something. What is happening? We are introducing a condition.
Okay.
So we come up with an appendix to the rules. We call it Appendix EU. Appendix EU paragraph EU 11 says that if you have lived in the UK up to this point of the agreement, you can apply to continue to live indefinitely in the UK. And we call it settled status. And it says that if you have not lived in the UK for 5 years, then you'll be given pre-settled status. What it means is that the moment you cross the 5-year line, you have to be upgraded.
Okay.
Question will be, does that upgrade comes with a condition? UK introduces a condition that you have to apply to upgrade.
Mhm.
Then we take a step back to look at section Article 21 of the Treaty on the Function of the European Union. Says that you have free movement. And therefore, if you choose to live here, the agreement is that apply to live forever if you have done 5 years. That means all those who haven't done 5 years, they couldn't get indefinite because they have not done 5 years. What if they do 5 years? Then there should be automatic upgrade. That is the, if you stretch the argument.
Right.
Now, the UK introduces a condition that to be able to be upgraded, you have to make an application for upgrade, which is the settled status, if you were given less than settled. Then so that condition has undermined the essence, the spirit of the withdrawal agreement, which looks at section 13, that whatever conversation we have within the agreement should take its import or power from the treaty right or treaty charter itself. So if UK is introducing new thing, then we are undermining the charter. So what happens? A body comes together called Immigration Monitoring Authority, an independent monitoring authority. The Independent Monitoring Authority challenges the Secretary of State on this point. Now, why do you introduce a condition that seeks to undermine the treaty rights of nationals living in the UK? Because the treaty right says I have free movement without any condition. And that is why we don't even pay fees when we are making our application, because fee is a condition and that will undermine. So if fee is a condition and you have removed fees, why do you introduce a condition for people to reapply if they want to stay permanently, having done 5 years residence? So the matter goes to court. It is considered, and Law Justice Lane concludes that that point undermines the withdrawal agreement, because the whole essence of the withdrawal agreement is to give impetus to the treaty rights. So if you are going to ask people to reapply when the pre-settled 5 years has elapsed, then that is a condition. Meanwhile, there's no condition. So who are we looking at? We are looking at EU nationals and to an extent their family members. But we go to their family member and look at where the condition lies with the family members. So you can see that the nationals themselves, there should be no condition. So if you are going to ask them to reapply, what if I choose not to reapply? Will I be affected? On the point of policy, yes, but on the point of law, within the treaty rights, then they're going to be affected. So we say no. So the court says that anything that creates impediment in the way of those nationals having regard to exercise their rights of residence in the UK within the treaty right will be undermining, and therefore it's incongruous. So that's the first point.
Okay.
So if I have pre-settled as a national and I am 5 years in the UK now, I've lived in the 5 years in the UK for 5 years, do I have to be upgraded automatically? The answer is yes.
Okay.
Do I have to be asked to reapply? And that is an obligation on me to reapply. But do I have to be given a duty to do that? No, it's an existing duty. And my duty is to come in, and I have come. So the UK's duty is to ensure that my treaty rights are supported or allows me to exercise my treaty right.
Okay.
So so this conversation goes to Parliament, and a consideration is given. And within the changes, it says that those EU nationals, there will be a consideration to upgrade them if they are 5 years due. They will be upgraded to the settled status. And it says, and remember, this is a thought.
Okay.
This is a thought. The immigration minister's thought, parliamentarians' thought. Has it become law? No, but it's been featured in the policy. And the policy is saying that from 2024, the Home Office will take steps to give effect to that point. There are other people saying that from September, this will happen. What the minister proposes is that from September 2023, there should be 2 years upgrade. And that means if the person hasn't done full on 5 years, then the 2 years will still not be enough. That means now the Home Office is saying from 2024, they will give effect to this. The minister thinks that it should be from September 2023. So are we saying that from September 2023, everybody will have automatic upgrade? I would say I don't think so. So those are the differences. Now we move on. What the law is again saying, Section 13, withdrawal agreement, goes down to point out that nationals of the European Union living in the UK should be allowed to continue to live in the UK without any impediment. And that is where the automatic upgrade goes to. So first off, for the nationals living in the UK, nationals. Meanwhile, the treaty allows for family members of those nationals to move and to reside in other member states with them. But the point is family members.
Okay.
So at any point in time, if you are a family member, you have to prove that you are a family
A family
member.
member.
And you
Okay.
haven't ceased to be a family member. And therefore, there's obligation on family members to prove something. For me, as a national, I don't have to prove something. All I have to prove that I have entered the UK before or on 31st of December 2020 to exercise treaty rights. And therefore,
But for
those
family
expectations
members, they will have to be
continue.
the proof.
Family members within the TFEU, that is the Treaty on the Function of the European Union, Article 6, Article 21, 49, 18 looks at other people, including family members. And what the family members must prove is the relationship. Very important. And the relationship should have existed before or on 31st of December 2020. And also dependency, such that family members, depending on who they are, had to have been depending on those nationals for their survival, essential living needs. And that is why when family members are making applications, they either have to prove relationship plus dependency, or they have to prove relationship depending on who they are. If you are a parent, you prove relationship. Dependency is presumed. If you are a child, up to 21 years, dependency again is assumed or presumed, and therefore you have to prove relationship. But anybody 21 years and above as a child, you have to prove dependency and all that. So we also know that extended family members from 2020 ceased to have right to reside with their family members who are nationals living in the UK. So we say the extended family members are over, but nuclear family members continue. So there is a distinction. Therefore, the point we are making is that yes, case law is clear. The case of independent monitoring authority versus the Secretary of State, and this is giving power to those nationals to continue to exercise their treaty rights. And therefore, if they choose not to extend by application, you cannot force them out. So your policy cannot undermine the treaty provisions. But if you're a family member, even though you have the right within the treaty, you have to show that your relationship that gives you right and the dependency that gives right still exist. So those are the nuances, but we'll continue to
Well,
have this
the
conversation as we
question,
go along.
well, if you just joined us, Lawyer Asmah is explaining and answering the question, should I renew my pre-settled status or wait for the automatic renewal? You don't have to, as it's been explained. But what happens, in situations where people are asked at work, what's your status, bring this and the rest, and that, this and that, and that thing. Do we have to prove anything, or once the policy favors us and we don't necessarily have to do that, we can sit back and nobody can touch us?
Right. Now, let me point this out. The minister, Lord Murray, the Minister for Secretary of State for Immigration, the Under Secretary of State for Immigration, his position is this, that if the Secretary of State is able to implement this point of giving automatic renewal, so extension to those people who qualify, then it will free resources for other things because there's so much pressure. So why do you bother spending money and time deciding applications which has automatic right anyway? Then why don't you just trigger automatic extension? So you can see that it's a matter of exigency and necessity. So you can see the mind of the minister or parliament is cost savings and convenience.
Right.
But we have also the legal argument. So practicality, somebody's pre-statute is expiring. You need to work. Are you going to wait till Home Office start implementing before you continue to work? The common sense thing is to renew. After all, it's free anyway.
Oh, well. Well,
Common sense
if
thing.
it's free, I raise my hand.
But pre-settled and settled state applications have always been free. And I told you that it's free because within the treaty obligations, there should be no impediment. And therefore, if you introduce a fee, that's an impediment, and that will be undermining. And that's why there's no fee. That's why every immigration application, there is a fee, but this one, no fee. And there's a reason. That is the reason. But the point we are making is that practicality. Your pre-settled is expiring, let's say, next month, or let's say December.
Okay.
And let's assume that the automatic renewal for those who qualify, and I said that they are nationals, those who you are a national from European, any of the countries living in the UK, pre-settled because at the time of your application, you had not lived in the UK for 5 years. Now it's expiring. You've got 6 months left. There's this conversation going on, and somebody tells you, Massa, wait. After all, they say you don't have to do anything. But what is it that you have to do that is costing you? Just put in the application. You know how to use the computer. Put it in, and they will decide it for you. But if you choose to wait and your employer says your visa has expired, then you're going to go to another hurdle to explain to the employer that there's a case law which gives me rights. The employer may not understand the case law. And between the time you are able to convince the employer up to the point that conversation started with the employer, it would have cost you your job or even having to stay home, your daily bread. So what I would say is that if your pre-settle is aspiring, take steps to renew. After all, it's free. It's free for Home Office. Of course, it's not free if you think you need legal service, but it's free for Home Office. So there's no visa fee to the Home Office.
Okay. So then the obvious answer is you don't have to, but do it because it doesn't even kill a fly. Whatever it is, you may need it. So don't wait till whatever time, but do it just to save yourself time, and it's convenient. But you don't necessarily have to do it. Is that correct?
If you are a national of a member state.
Okay.
But if you are not a national of a member state, then this conversation may not apply to you completely because you have to prove your status within the rights. How did you obtain your rights or derive your rights? Is it by family relationship? And if that's the case, how do you show that indeed you depend on that family member dependency? So whether this or that, the family members have obligation to prove who they are.
Even at
So
the
at
point
any,
of renewal.
but if you're a family member, it's possible that your relationship with that EU national has ceased. Are you still a family member? Will
No,
you
it
then
doesn't.
still derive a right, depending on the circumstance? And if it's a case that it has ceased, but it's been as a result of an intervening factor, i.e., death or divorce, then you have to prove it, don't you? So you can see that there are nitty-gritties to do with family members. So the nationals, 100%, but family members, it's not 100%. So if you're a family member, let nobody deceive you that they said everybody with pre-settled. But they said everybody who is a national of a member state and has pre-settled now has a choice.
Okay.
But even that choice must be exercised with discretion.
Well, that's Charles Asmah explaining our topic for us. And what we have been looking at is whether we need to renew our pre-settled status or wait till the renewal. Now, the expert advice and the convenient one is, listen, you don't have to, but please do it because you may need it. But you have to prove that you are who you have said you are. The numbers to call 07399, sorry, 07399208468. And WhatsApp number is 07950422780. I'm here with my resource person, friend, and colleague, lawyer Charles Asmah from BWF Solicitors. BWF Solicitors, a proud sponsor, is located on the 4th floor of the Anna House, 214 to 218 Tottenham High Road, Seven Sisters, Monday to Friday, 9:30 to 6 p.m. They are open. So go to them, send in your conversations, ask them to help you put in your applications when it comes to putting together your will, if it's about property advice and the rest of it, marriages and divorce issues, all these things. If you need a lawyer, talk to BWF Solicitors, 0208 493 7340, 0208 493 7340, or 077 127 61884, 077 127 61884. BWF Solicitors. As we say in the local parlance, sorry. Yes, we salute you, we doff our hats to you, BWF Solicitors, because you've been there and you always be there for us.
This is our world. Here we are in our community. There are the laws, there are the regulations. We have BWF Solicitors. BWF Solicitors, experts in all aspects of the law, family law, civil litigation, all immigration and nationality issues, representation in court, marriage and divorce. We pride ourselves to give you excellent legal services and follow through till we get you the right result and decisions. That is our mutual satisfaction. We have a team of excellent qualified solicitors and support team to help you every step of the way. Our senior partner, with over 30 years of unbroken service to the community, is a member of the Family Law Panel and has advised several lawyers and institutions in many legal matters. He is qualified to practice both in the UK and in Ghana. Come to us. Speak to us. Let us represent you. We are your trusted community partners when it comes to the law. Locate us on the 4th floor of the Anna House, 214 to 218 High Road at Seven Sisters in North London, N15 4NP. Nearest train station, Victoria Line to Seven Sisters Station, exit number 2. We are open for all consultations from Monday to Friday, 9:30 a.m. to 6 p.m. Weekends by appointment only. Call us now on 0208 493 7340 or 077 127 61884. BWF Solicitors, your trusted legal partner.
Okay, thank you very much and welcome back. We live on BWTV and we featured on BWF Solicitors Facebook page and BWF Solicitors YouTube page. And as I mentioned earlier on, when you come on board, pick up the page, share. If you're new, click on the notification button so whenever we put content on the platform, you'll be notified. And whatever runs your boat, do it. Either stick and stay or you come back to watch it. The content is live on our pages all the time and forever. You know, the internet does not forget, does it? Well, we go on to get you to interact with a lawyer, Charles Asmah. He's ready to pick up your call, 07399 208468 or 07950. That's for WhatsApp only, 07950422780. Lawyer, there's a question here. Asante Richard has put this one on. It says, will this either have positive or negative impact on someone married to an EU member but having joined him or her as yet as non-EU national? What would be an answer to that?
So somebody who hasn't joined this person is ostensibly living abroad, and they have to make application under the family permit application, EU family permit to join the member. So it says, will this have positive or negative? If the person hasn't arrived, then we are not even talking about the residence of that person, such that it will have automatic renewal. And again, that person is a family member. And so what will I say to this person is that if the family member intends to join the national of the European Union living in the UK, they have to apply within Appendix EU rules, meeting the requirement and joining their member. Once they do, they make application within, remember they have to have the pre-settled status first. So you apply for the pre-settled status. You'll be given 5 years because you would have been living in the UK for less than 5 years. Then again, you have to be living here. So it's not like you'll be jumped to. It says automatic renewal once your 5 years has expired. But we have drawn the distinction between those who automatically qualify and those who may still have to prove that relationship or dependency or both.
Well, let's go on to this next one that says, must an extended dependent family member have the same address as their dependent for their entire residency?
So, Braco, could leave this on.
Yeah.
We have to underline three words. Member, or actually, so family member is one. You are a family member, and you applied that you depend on that national. So you depend on that person. This person is also giving us another point. Same address. If you applied and you depend on that person, then of course you live with them. So I don't see why your address has now changed and you claim that you are still living and dependent on that person. And you're also saying that for the entire residency period, why will you sever that dependency or ties with the person and still claim that you depend on them? When the time comes, you struggle to. So your answer is that you applied to enter, to live with them, and to depend on them. If that is the case, you must prove when you are ready to extend.
Okay. Well, the next one here is from your namesake. He says, my name is Charles. I applied for settlement online and went to enroll my biometrics at a UKV class. To my surprise, they didn't take away my passport and my metric residence permit. Instead, they scanned them and gave them back to me. My BRP expires at the end of 2024. Question is, since I have my passport and BRP, can I travel outside the UK whilst my settlement application is still under consideration?
So, so let's leave this there. This person applied, but even though their visa still is not expired. So I want to understand the basis. So I applied for settlement online. So pre-settled to settled status, I suppose.
Well, hopefully, I suppose
it's not clear. But let's assume that a person applied to extend pre-settled to settled, and they didn't take anything. They don't have to take everything if they feel that there's no point. So they'll give everything back to you. Then technically, we send copies, and if they want, they ask for the hard copy or the original document. That is if. So it's not surprising that they gave it back or them back to you. My question, I have my passport, I have my BRP. Can I travel while the application is pending? Now, if you apply to extend, and again, so there are people who have done 5 years, even though their visa will expire sometime in future. So if you have done 5 years sometime in future, I will say to this individual that this it might not take long for you to get your permit or your decision. Normally, they will not give you a new card because you have a card already. So once the card is expired, you have to apply to have it replaced. But once you have your decision, then you can travel. There might be more information that we need to be able to ascertain the full facts of your situation to be able to advise fully. But suffice to say that patience is a virtue. If you wouldn't bother much, wait till decision comes. But if we have full fact of your situation, we'll be able to advise better whether you can wait or you can leave and come later.
Well, Kevin Asamoah, you say you watching us live. Aiko, Kevin, thank you very much for your support all the time. Tele Duma is saying good afternoon to everybody. Now let's continue with the questions. Benasari, yes, we see you as well. Good afternoon, Benny. How much is the application fee for child settlement, indefinite leave to enter, I guess, from outside the UK? Do children pay the IHS, that is the health surcharge, for such applications?
So the application for children, I suppose this is under Appendix FM. So the one I submitted last week, the child paid $2,054 for the main application, and they said that IHS is zero. Normally, what happens is that once the visa decision is made and they are going to grant, they ask you for the IHS for the child. So they more or less give the IHS to you on credit until they ask you to pay. But how much? The most recent one without IHS was $2,054.
You can send in your question and your contribution to the comment section,
And it's
or send it
dollars, please.
dollars. Okay, send it to our WhatsApp number 0795042278. If you want to join us by voice, the number is 07399208468. 07399208468. Let's pick this one. I came to the UK with EU family permit as a family member of EU national. After 5 years, I applied for permanent residency and it was refused because I'd moved from my mother's house to form my own family. When EUSS was introduced, I applied, but I was refused again. But my twin, that is a kids, applied based on my mother and it was successful. Please advise me. My twin kids successful. Mine refused, the same EU national we depended on.
Very good test case. Remember, I told you that, and that is even good to address the point. We are saying that EU nationals get automatic extension. What about their family members? Family members must prove that there's still dependency and relationship, or either of them, depending on their specific circumstance. So this is a test case. So we have the grandchildren and the child making an application. The child is over 21 years. So the child must prove dependency, even though the relationship is obvious. Why did this person struggle to prove dependency? They have moved on. They live independently. Because he says that I moved from my mother's house to live on my own. What they are saying is that they are able to fend for themselves. They don't depend on their mother. So if you don't depend on your mother, then you cannot prove dependency when you are due to renew. And that is why you are refused. What about grandchildren? Grandchildren are under 21, and dependency is presumed for children or grandchildren. And therefore, the grandchild is able to prove relationship. They don't have to prove dependency, and therefore they must be granted. And they were granted based on what the grandmother has. That's the difference between you and your children.
Okay. Well, lawyers explain the difference. If you need any further conversation on this one, you can call into the office 0208-493-7340, 0208-493-7340. 0. Asante Richard, you are asking for lawyer to answer your question. I think he was actually addressed earlier. Let me see if I can pick up the question. Probably you must have missed your answer. Asante said, would this have either positive or negative impact on someone married to an EU member but haven't joined him or her yet as an EU national? I think, lawyer, you mentioned that, didn't you?
Yeah, and I think he says his network failed him, so he can always go back and listen. But let me just be brief. So, if the person hasn't joined, they can apply to be considered for family permit to join their EU national, showing the relationship and dependency. And once they come in, they'll be given 6 months. Once they come in, they have to immediately apply under the preset under the EUSS provision for 5 years, because they would have only been living in the UK for less than 5 years. For now, that concession is there. It hasn't been changed. Those applying from abroad is still ongoing.
Okay. 0739920848, or send a WhatsApp text voice note to 07950422780. This one from our text message is, hello, Brian Kwelo Asmah. I'm EU settled status and I'm due for naturalization in October this year. I have a master's degree here in the UK and have live in the UK test. Also 5 years of P60s. Do I need to add anything else? I'm a volunteer for a UK charity. Do I need a letter from them to add as well? I'm giving myself a shot on this because of the changes in good character. Otherwise, I may need to wait until 2026. That will be the 10-year mark. What do I do? Thank you, lawyer. Can we help, please?
Thank you. Well, the person says he's lived in the UK for at least 5 years, because he said there's 5 years P60s or 5 P60s. There used to be the case that 10-year concession, 10-year provision because of point of marriage, but the changes that came previously suggested that you have to show 5 years residency, so that that concession will be consistent with schedule will be consistent with the relevant provisions of Section 6 of British Nationality Act 1981, Schedule 1. So that one standard naturalization, 5 years residence. But EU used to be the case that you have to show 10 years residence after the date of marriage and all that. The two have been made equal, therefore 5 years. So if this person can prove 5 years, they have life in the UK already done. That test result is permanent. They have masters in the UK. They can show that and all that. That's it. They are ready. They can put in the application. They just have to match their document against the criteria. If they ask a lawyer to assist, of course, the lawyer will also do the due diligence and to ensure that they meet the criteria and the application is submitted. And Bracco, could I even point this out? So you can see that naturalization is not within the treaty right.
Okay.
Because treaty right is to come and live and work and go back if you want to and remain if you want to. Remaining means you become permanent, but it doesn't give you right to become a citizen. And therefore, when it comes to citizenship, you have to make deliberate attempt to apply to be considered for citizenship. So let's take note of that as well, so that people wouldn't say, well, if this is automatic, then when I'm due for naturalization, that should also be automatic. That is a separate conversation.
Well, then I have an extension to these conversations. 2 points. Let me put the first one out. For instance, if I have applied and I got my indefinite leave to remain through that concession where they give for what's the name of it? The DV cases. Now, when I have stayed on my indefinite for a year and I want to naturalize, would I qualify for a fee waiver?
Yeah, that's a very interesting point. Okay, so fee waiver. Let me address the fee waiver point so that we have the context. So, Section 3 of the Human Rights Act 1998 says that any law or policy introduced by the government that contravenes article human rights, relevant aspect of the human right, will be inappropriate, because the person's right under the Human Rights, European Convention on Human Rights, Article 8, especially right to family life, right to private life, says that if I have the right to private life or family life, then if you restrict me or do anything to prevent me from exercising that right, then I cannot exercise the right. I hope you agree with me. So why should the government deliberately introduce an obstacle to restrict people from exercising their right? So Section 3 says that if you do that, you are preventing people from exercising their relevant right. Therefore, don't. So the question is, what happens? Now the government says, all right, if you are going to exercise your right under immigration rules to apply for family application or private life application, you can request for a waiver. Request for a waiver. And if you do, we will check to see whether indeed you qualify based on your destitute situation and other factors. If you do, we will not restrict. We will grant that so that you can apply. If you don't, then you have to pay. That means you can afford, because Appendix FM applications are payable. Now, naturalization or citizenship, so to speak, is not an Appendix FM application. It's a pure citizenship or nationality application. And that one is not compulsory. So you cannot, if you are an adult, go for that. However, if you're a child, because we are talking about children's best interest, the rules have been relaxed so that children who are making application for citizenship, registration to become British citizens can apply for a waiver. And the argument is that the parents cannot afford. And therefore, if the parent cannot afford, then we are punishing the child. So the child is due, parent cannot afford, do we punish the child? So the law has been relaxed so that the children can take advantage of fee waiver. So the only nationality application that attracts fee waiver is that of children. The adults, you have to pay, and therefore, unfortunately, no.
Unfortunately, no. We're moving on, soldiering on 90 minutes after the 17th hour here in the UK BST. The program is The Community and the Law, and lawyer Charles Asmah from BWF Solicitors is helping us address the question changes to immigration rules. The specific question we're trying to address here this afternoon is, should I renew my pre-settled status or wait for their automatic renewal time? Well, he's addressed that, and we picking up your questions and your concerns. 073-992-0846 if you want to join us by voice, or text on WhatsApp to 07950422-780. This one from God's Favor Me Royal Queen B. I came to the UK as a EEA family member, applied for the settled status after 5 years, and was given an indefinite leave to remain. I think that's what you mean. I'm 24 years old, and I've got my dad and half brothers back home and other relatives. Who can I send for with my documents? Okay, lawyer.
Maybe who can I, which of them can depend on me to join, or who can join me, so to speak. So this person is a dependent of an EU national, but for now they are settled. So they have indefinite leave to remain. Of course, they are adults. Now, if you have your brother, so to speak, siblings, because you have indefinite leave to remain, or even if you had pre-settled, even if you have EU nationality, these people are your extended family members, and extended family member provisions do not apply any longer in the UK. So your siblings cannot join you, even if you're an EU national. Now you are a family member of an EU national, and so you now you have become settled. Your siblings, if you can prove that your siblings need your support, care, because of their situation, then you can apply under Appendix adult dependent relative. So that, but you have to prove it's a very high threshold application because they are unwell and so severe that they cannot carry out daily tasks. And you are the one providing for them, supporting them, caring for them in their country where they are. And that support is no longer available because of the change in circumstance. There's medical evidence to show the history of ailment or medication and what have you. And there's nobody else apart from yourself to provide the care. Then you can apply for consideration. You also have to show that when they come, you have accommodation, you have facilities in place to ensure that they now get the care and support that they are not getting where they are. And you can see that that's a very daunting task, but it's doable if you can go through the checklist. So ADR is available. Otherwise, you have to look at if these siblings, depending on the circumstance, if they are old enough and they can come as students, then you can sponsor them to come in as students. If you can also ask them to make an application for look for a job, find a job, make direct applications, personal applications to the employers for consideration and offer of a job, then they can come in under the skilled worker program. So these are the options open to these family members of yours, but you cannot directly under the circumstance.
Now, I remember this text came earlier on where this person said has EU settled status due for naturalization in October this year, has a master's degree in the UK, got 5 P60s, was asking whatever that was needed next. There's a continuation. This one, it says, I got my settled status through Zambrano. Before then, I didn't have any status. Hence, my statement on that I was giving it a shot due to the 10-year good character requirement changes. Does that make any sense?
Right. I mean, whether they got it through Zambrano or what have you, what the person is saying that they have settled status and they have stayed with, or they have held it for at least 1 year. Mm-hmm. They have lived in the country for 5 years and they can prove that long residence of 5 years. So, as I said, there's parity between citizenship route, all right, for EU nationals and family members, and also that of other migrants, so that it's in tandem with the Schedule 1 of Section 6 of the British Nationality Act 1981. So if you're able to prove what you have already mentioned, then the application should succeed.
The application should succeed, and you're succeeding when you deal with BWF solicitors. Somebody says that work. Let me put this one on. Okay, let's put this on. He says, I want to come to the UK on work permit. You text us with a number that starts with +92. I suppose it's in the Middle East somewhere. How can a person come to the UK on work permit? Laura?
They can come to the UK when they find an employer, apply to the employer for a job. They go through the process, get shortlisted, pass the interview, receive offer letter, accept the offer letter. Then they receive the certificate of sponsorship. They apply, meeting the English requirement and what have you, maintenance. If the employer is not sponsoring their maintenance, then apply to come in.
Okay. 07392084680 07950422780. And Effie Bafo, thank you very much for joining us. Margaret Adu Mensa calling on Nana Rama Nana Sewa to join us. Kindly share, and share. That's the only thing you can do for me this afternoon. Let's get a lot of shares and increase and improve and make the algorithm look very nice. It's the community and the law with lawyer Charles Asmah from BWF Solicitors.
Our private client services team is recognized for providing clear and practical legal advice to our clients in the United Kingdom and Ghana. Expert help with will writing, probate or estate administration. Our will writers and probate lawyers can act for you to obtain grant of probate and carry out estate administration on your behalf. The probate takes place after someone dies. If there any inheritance tax. If there is no will, the interstate and inheritance rules require similar responsibilities. Our lawyers offer strategic and practical solutions to the issues which clients face, whether it's in relation to succession planning, will preparation, probate and the administration of estates, immigration and visas, contentious family or probate disputes, administering estates often with inheritance cross-border issues, international trust advice including residence, domicile issues, wealth preservation, a fast, efficient service from SRA-regulated professionals, transparent pricing. BWF Solicitors, let us take care of probate.
Okay, welcome back. Thank you very much for keeping faith with us. Moving and soldiering on. Very soon, we will be looking at our nugget again and also going to our quiz segment. Now, listen and look at this. The Home Office cannot refuse an application or your visa at the airport on grounds of dishonesty or some other serious allegations without first informing the person of their consent and giving them a chance to respond. The courts have said that it is unfair to do that. This is known as a minded process and is based on two cases that BWF solicitors through their nugget have cited. First, Tazim versus Secretary of State for the Home Department, 2023, England and Wales High Court case 1828. Then we have Bala Jigari versus Secretary of State for the Home Department, 2019, England and Wales CA, Court of Appeal. Yes, I think I've gotten it right. Court of Appeal case 673. And with that, I will be looking at a case scenario and we see what action can be taken against the Home Office, or when somebody takes action against the Home Office based on the situation, what the likely answer will be. So get ready for that. We'll be coming to that very shortly. But in the meantime, we've got a brother Kevin Asamoah coming up with a text that's put on the platform. Let's pick that one up. Are the spouses of EU nationals with pre-settlement also receiving the 2-year extension automatically from September? No.
Yeah, so Bragoku, if you could show the law, Article 13 of the withdrawal agreement, if you could kindly...
Let's go on, I'll put it on right away for you.
So, so we'll come to that. But I think our brother's question has already been addressed. What we said was that much as the EU nationals themselves should be considered for automatic extension or upgrade within the treaty rights agreements, the nationals must prove that they continue to, the family members must prove that they continue to remain family members, and those who must show dependency are still dependent upon or still can show dependency. So the family members cannot be treated automatically, just like so much as the family members, so much as the nationals themselves. So let's look at Article 13 of the withdrawal agreement.
Yes.
There are 4 sections here. Section 1 refers to nationals, citizens of European Union states, so the nationals, EU nationals. Then what two, which is Article 13.2, and here we are looking at Withdrawal Agreement 2020. Two looks at family members of the nationals who are themselves nationals of EU or UK. Then we go to the third one, family members who are neither EU nationals nor nationals of United Kingdom. Then we go to 4, and 4 is where the law is. The host state, and the word is may not impose any limitation or condition for obtaining, retaining, or losing residence rights on the persons referred to in paragraph 1. And mind you, paragraph 1 as the nationals themselves. Paragraph 2 are nationals who may be EU nationals, so family members who may be who have become nationals or who have become nationals of UK. And the third one are the national family members who are neither nationals nor of EU or nationals of UK. An example is Kevin's question, where the spouse who is not a national but a family member of the national EU national. So here, the word is may. So Article 13.4 uses the word may. And that is why, even though the nationals may be automatically considered for extension or upgrade, then family members of the national may not be automatically considered, because those people must always meet some conditions. The nationals, they don't have to meet any condition because the treaty does not impose condition. But the family members, the condition is that you are a family member and or you depend on that family member for your essential living need. So if you don't depend on the family member, then you cannot derive any rights from the family member. And if that family member has ceased to be your family member, then you cannot derive the right. Of course, we have what we call retention of right, but that is also exercised with some conditions. So I would say no, the automatic extension will not cover family members who must prove certain things before the application is considered. And what the policy says is that even though there's going to be automatic upgrade for those who qualify, they are going to be very careful so that it will not lead to fraud and undermine the entire process. So that is something they have also said. And that is why we can say that it's going to be automatic, but it may not be automatic for everybody who has pre-settled status in the UK.
You can just call us and come on board. You can text or send your comments down to the comment section underneath the broadcast. And Laura Charles Asmah will be addressing that. Your WhatsApp text messages are to be sent to 07950422780, or you can call in and ask your question 07399208468. The person who sent in the question about the work permit is from Pakistan, and he says, I think he must have missed that bit when you answered it, but what will be the requirements for a work person coming on a work permit from, say, Pakistan?
Right. It doesn't matter which part of the world you live. The rules apply to everybody. So the person living in Pakistan, just like anybody for that matter who has already entered the UK, will have to first look for a job. They find the job and apply, go through the recruitment and selection process of that employer. If they are successful with the application, they will be given offer letter. And after that, they will be given certificate of sponsorship, where the employer must sponsor them to come and work in the UK. That means the sponsor must have a license. So when you are looking for an employer, you have to check whether the employer has the license to employ you from abroad. Once you go through that, the employer issues you with a certificate of sponsorship. You apply depending on the specific route you are applying under. If your application or your job falls within the occupation shortage route, then you will be able to apply with some minimal challenges in terms of how much the employer must pay, in terms of whether you have to show maintenance or not, and so on and so forth. Now, if it is not within the shortage occupations, then the employer must show that they are able to pay that much. They also have to show that the job was advertised and nobody was available to take it from within the UK. That is why they offered you, and so on and so forth. But if you're in Pakistan, my brother or my sister from there, you can either consult an immigration law firm in the UK. You are listening to BWF Solicitors. You can approach, but before you do, make sure that you've already got a job and you want to apply. If you haven't got a job and you don't have the COS, then we cannot assist because we do not offer jobs. So that is one thing I want to add.
Yes, you can join us now, 0739920848 or 0795042270. Yes, very soon we'll be going over to pick up our quiz, and it would be based on the nuggets that I read. I'm going to do that again before we cross over to do our quiz. A home office cannot refuse an application or your visa at the airport on grounds of dishonesty or some other serious allegations without first informing the person of their concerns and giving them a chance to respond. The courts have said that it's unfair to do that. This is known as a minded to process based on Tazim versus Secretary of State for the Home Department 2023 England and Wales High Court case, and also on Balajigari versus Secretary of State for the Home Department 2019 case, England and Wales Court of Appeal case 673. And it's live on the program Community and the Law, and live on BWTV, also live on Facebook and YouTube for BWF Solicitors. Now, we're taking this quick and short break, and when we come back, it's time for us to do our quiz. Are you ready? Yes, I know you are. We'll be right back. Welcome back, and thank you for sticking around. It's time for us to test our knowledge on the nuggets that I've played over and over again. But now this is my question, and well, it happens to be one of my favorite parts of the program. Okay. Now go off. Well, I will put it another way. Abbas Nuhu arrived at Heathrow Airport on a student visa. When he was asked to be interviewed, he requested for a Chi interpreter, although as a student he needed to have passed an English test called IELTS. During the interview, he was unable to answer questions about his English test results and university qualifications. The immigration officer said because he couldn't speak well and suspected the IELTS English pass certificate was fake, he was accused of dishonesty. The immigration officer cancelled his student visa. Abbas brought judicial review against the decision. What is likely to happen in the court's decision? Now let's look at the scenario again critically. Abbas Nuhu arrived at Heathrow Airport on a student visa. When he was asked to be interviewed, he requested for a Chi interpreter. Although as a student, he needed to have passed an English test called IELTS. During the interview, he was unable to answer questions about his English test results and university qualifications. The immigration officer said because he couldn't speak well and suspected the IELTS English pass certificate was fake, he was accused of dishonesty. The immigration officer cancelled his student visa. Abbas brought a judicial review against the decision. What's likely to happen in the court's decision? One, the application will fail because he can't speak English. The application will succeed because the decision was unfair. Three, the application will succeed because allegations are not serious. Okay, now let's see what answers you have. Even though I'm going to be quiet and silent about something, but let's see what answers you have. Is it 1, 2, or 3? Keep dropping the answers on the chat or send them to text 0795042270, or you can also text it to 0739920848. Abbas Nuhu arrived as a student. When he was asked to be interviewed, he said, well, yes, I agreed to the interview, but I need an interpreter. Although as a student, you needed to pass your IELTS. And during the interview, the officer thought that this person wasn't able to give me enough information, and I don't trust the answers about your university qualification and your test results, so I think something is fake here. So then I'm going to cancel your visa. Abbas said, you can't cancel my visa just like that. You need me to give you some explanation, and then you have to notify me. Now, remember when we were looking at the nugget, it said that they cannot refuse an application of visa at the airport on grounds of dishonesty or some other serious allegation without first informing the person of their concerns and giving them a chance to respond. Now, go back to the quiz and see if they were given a chance to respond. The immigration officer said he could not speak well and suspected the IELTS English pass certificate was fake. He was accused of dishonesty, so they cancelled the visa. What's the answer? Is it 1, the application will fail because he cannot speak English? Is it 2, the application will succeed because the decision was unfair? And 3, the application will succeed because the allegations are not serious. Let's see what you have. Am I missing any answers? So you haven't brought anything. Well, I've got Sylvester Yeboah Fojuo says the application will fail because the gentleman could not speak English. Let's look at Richard Enning. Richard Enning says that number 1, the application will fail because he cannot speak English. That's Richard's and Sylvester. Both of you say it's number 1. Let's move on to, okay, I've got yours here. Abi Apia says it's number 2. The application will succeed because the decision was unfair. Okay, Abi Apia, thank you very much. We've got yours as well. Which one is next? Keep it coming, keep it coming, keep it coming. 0795042270, or you can put it in the comment section, both on Facebook and YouTube. Benasari comes in and says this is number 2. The application will succeed because the thing was unfair. Okay, Ben, thank you. Let's look at what Kevin says. Kevin says 2. He may be speaking under duress, so he will succeed. And he adds amen. Okay, Queen God's favor me, Royal Queen B. He said it's number 2. The application will succeed because the decision was unfair. Okay, I'll take just about one more and I'll go to lawyer for the explanation and, of course, the answer. Abbas Nuhu arrived at Heathrow. Godlove Asamoah, you says number 1. Okay, Godlove Asamoah says number 1. Let's put that one up so you know you brought your answer. Abbas Nuhu arrived at Heathrow Airport on a student visa. When he was asked about to interview, they said, yes, I will, but I need a tree interpreter. Although as a student, he needed to have passed English test, that is IELTS. During the interview, he was unable to answer questions about his English test results and university qualifications. And the immigration officer said because he couldn't speak well and suspected the IELTS English pass certificate was fake, he was accused of dishonesty, and the immigration officer consequently, cancelled the visa. Abbas said, no way, I will appeal against it. Did a judicial review against the decision, and we thinking from what we know and learned, what the likely outcome will be. One is saying that the application will fail because he cannot speak English. Two, the application will succeed because the decision was unfair. Three, the application will succeed because the allegations are not serious. Now, two of the answers say succeed. One says will not. Lawyer, help us.
Thank you very much. So I'll give the answer, then I'll give the explanation afterward. So the answer is that the application will succeed, and the reason is that the decision is not fair under the circumstance. Why is the decision not fair? We are looking at somebody who is suspected of dishonesty, in that he might not have even passed the English test, yet he was able to provide the certificate. So he might have obtained it. It's a fake document, so to speak, and that's dishonesty. The person was given interpreter or an interpreter. So the nugget per case law, the case of Tazim 2023 and the case of Balajagari 2019 are clear that whenever the Home Office suspects somebody of dishonesty, they do not have to conclude in haste. They have to give the person opportunity to make a representation to clarify the matter. And until they are satisfied, they have to do what we go through the minded to process. So if they are not able to go through the minded to process, then they cannot conclude. Now, these people or this person did not go through the minded to process and concluded that because they were not able to answer certain questions, they might not be even truthful about the document they provided. So the visa was cancelled. Now, we also see that this person, though, say that they passed the English test or become is an university student, opted for Chi interpreter. The fact that you ask for an interpreter doesn't mean that um, the document is fake. Because if English is not your first language, you are at liberty to seek interpreter. So this person sought interpreter. Now, the case of interpreter can also be very, very problematic for applicants because the interpretation can be in error. So you are speaking your language, nobody can hear you except you and that person. This person is translating to the border officer who is listening in English. So if the person gets it wrong with the interpretation, then you are doomed. So this is what happened to our friend. Now, there is a case law, the case of R. Mappa, and it's a 2003 case. So R. Mappa versus Secretary of State, 2003, says that when it comes to interpretation for applicants or during interviews, it can be problematic, and therefore they have to use that interpretation carefully. So they have used the interpretation, they have relied on the answers from the interpreter, they have concluded that this person has been dishonest in obtaining the visa, and therefore they've cancelled it. The matter goes to court. What the judge will say that, did you give them the minded to notice to tell them that we are intending to cancel and refuse if you have something else to say, so that they have granted bail, so that they go through the minded to process. He didn't do that, and therefore the fairness has not been followed, and judicial review will succeed.
So then, in this case, the answer is number two. This is because he was wrongly denied the opportunity to comment on an allegation of falsified English language qualifications. The Home Office can't refuse an application on grounds of dishonesty without first notifying the person of their consent and giving them a chance to respond. Thus, as lawyer has explained, is known as the minded to process. So, as we said, the answer is number two. With that, I would want to come back to Lawyer Charles Asmah. So we do final bits where he would summarize what it is that we discussed. Then I'll come to draw the curtains down. Lawyer.
Thank you very much. So today we asked ourselves a simple question that with the policy that has come out, changes in the policy, if I have pre-settled status, do I have to renew when I'm due or wait till the windfall comes? We advise that there is law and there is practicality. In terms of practicality, please renew because you may need it for work, you may need it for education, you may need it for your existence in terms of your whatever you need to survive in the interim. So renew. However, if you feel that you want to be assert your right, then you can wait. And once you wait, the consequence will be what I have mentioned. But you have a choice to do or to wait. But that is only for nationals of EU member states. Family members of nationals of EU member states, because they have to meet the criteria for relationship and dependency, or both, they have to definitely go through the process. So their case may not be automatic. So at any point in time, they have to meet the criteria to renew or to extend. Therefore, conclusion is that you can wait, but be careful and exercise that choice with discretion. If you need it so badly, do it yourself. It's free, and therefore it's better to do it and wait for the future extension than to just wait and you not being able to meet your employment or educational obligations or conditions attached to that.
And with that, I want to say thank you very much to my friends, my brothers, and all the wonderful people from BWF Solicitors for your kind sponsorship and, of course, the support you give us with the share of knowledge. Today, we have had a very wonderful discussion. Your contributions, your questions have been so very helpful, and we've learned a lot. So to Lawyer Charles Asmah, I say thank you very much for your time. And I believe that same time next week, we'll have the opportunity of meeting either yourself or another person from BWF Solicitors. I always love a smile. Thank you very much, Lawyer Charles Asmah. And to you out there, haven't had time to sit with us for the past 2 hours, I say I salute you. Thank you so very much. Your time is so precious to me, and I value it. I will never take it for granted. But then I'm asking you to join me again, same time next week on the same platform, BWTV, where we'll be having BWF solicitors again to help us dissect another very mind-boggling topic. And to Sheila Ankra and to Padmo Dudu, Cynthia Brown, and all the wonderful people at BWF Solicitors, I say thank you. And not forgetting, most importantly, our principal lawyer, Bernard Owusu. Folks, it's been good. Thank you very much. Have a good evening.